First of all, my name is Ayufunali Sokubo. I'm the Registrar of East African Court of Justice. Now, my position as a registrar, I am like the engine of the courts. Just like an engine of a car, without the engine, the car can't run. So I take care of all the management of the courts, monitor how many cases are coming in, find out if they are properly filed. If not, I can take back the documents to the lawyers or whoever filed them and tell them correct this. Then arrange the schedule of judges when they will come to hear the cases. Even prioritize which one should be heard first. Maybe others are filed under certificates, so maybe we start with those ones as the others wait. Likewise, I do that for the appellate division. We have 2 divisions. So all cases, first of all, start with the first instance division, except cases that want an opinion from the court, because we don't want to have conflicting opinions. So anybody coming to court, for example, he wants an opinion, maybe it's touching about the interpretation of the treaty or some things about violations, those ones go straight to the appellate division so that it is decided with finality. So I also manage the finances of the courts. We have sub-registries in all the capitals except South Sudan, but we are in the process of opening one, so that we have taken the court closer to where the citizens are, closer to where the residents are. You really don't need to come to Arusha to file your case. Go to any of those sub-registries. You will be as good as being in Arusha. You will file your case and we shall receive it.
What was the founding instrument of the court?
The founding instrument of this court is a treaty, Article 9 and Article 24. Article 9 establishes it as an organ. Then you go to Chapter 8 of the treaty, that spells out the whole provisions about the court. So it is grounded on the treaty. Of course, not to mention that it is a successor of the initial East African Court of Appeal in the original East African Community, which court also collapsed with the collapse of the original East African Community. So this one was recreated when the community was being re-established again. That is the founding document.
What are the official languages of the court?
The official language of the court is English, as per the treaty. Now, to make it easier for the citizens of the community, we say you can come in any language, so long as we have a translation of those documents accompanied with a certificate of translation that this is the correct translation. So in as much as the language is English, it should not stop people from coming to this court because they have difficulties in English.
Could you kindly tell us about the judges of the court in terms of how they are elected, is a tenure renewable, and how the president is selected?
Now, let me start with the president. The president is on rotational basis, where every country at one point will be the president of the court. So we have gone around Kenya, we have gone around Tanzania, we have gone around Uganda, we have gone around Rwanda, now we are at Burundi. So the next on the line will be South Sudan. So that one rotates. Now the judges are appointed by the summit. Now according to the treaty, they have to appoint somebody who is qualified to be appointed a judge in his own country, first of all. And if not so, then he must be a recognized legal scholar in the region or in the world, somebody whose name was recognized. Now, once you are appointed, you serve for a non-renewable term of 7 years. You finish 7 years, you go. Unless if you hit age 70, which is the retirement age of judges, before you have finished your 7 years. So we have had instances where judges have been appointed, they served 4 years, they served 5 years, they served 6 years, because when they were appointed, then that is the only period that was remaining for them to reach 70 years. So that is how they are appointed. And also, they are appointed, every country has got a judge in first instance division and in the appellate division, because the treaty provides that the appellate division will have a maximum of 5 judges. As of now, the appellate division is full. In the first instance division, the treaty says you'll have a maximum of 10 judges. So we have 6 in the first instance division. We still have vacancies for 4.
And how does one apply to become a judge? Is there an application process or is it more of a nomination process?
It is more of nomination to your partner states. How they select you is their own business. We have not put down any measure that this is how a judge should be selected or he should apply. So they have their own mechanism of finding out who is suitable to be sent to East African Court of Justice. All we do is to notify them that a vacancy is falling open and your country is supposed to nominate a judge who will then be appointed to the East African Court of Justice. As to how they do it, that is a national issue. And once the name is sent, we respect it, so long as it has the qualifications, then we forward it for appointment.
One of the most popular questions, does the court have a human rights jurisdiction?
First of all, if you interpret the law strictly on the 4 corners of the papers, you will say it doesn't have human rights jurisdiction. But remember, a court's work is to interpret. So in as much as, if you look at the documents, you may say they don't have jurisdiction, the court has been able to interpret some of those provisions that then gives the court a human rights jurisdiction. And we have very many cases of human rights jurisdiction that have been decided and which the partner states have accepted. So I don't think even the partner states themselves have issues with the court making decisions on human rights jurisdiction.
And who can file a case before the court?
Who can file a case is a resident of the community. And you must distinguish that with a citizen of the community. So a Chinese or whoever, so long as that person is within the geographical area of the community and he is there legally. So a foreigner with a work permit or resident permit, allowing you to be in any of the partner states, can bring a case. That then of course includes even the citizens, the people who stay within the geographical area of the community. Now I'm saying the geographical area because we have had a case where a citizen, simply because he's living in America, he was denied an opportunity to file a case. And the reasoning of the judges was the framework of the community wanted the people who live within the geographical area of the community are the ones who should be filing the case, not people who live outside. So it is a resident, anybody who is a resident within the community.
And how does one file a case? Does it have to be physically or is there an electronic process of filing cases?
The world has moved forward, and it would be wrong for the court to still operate the way we were operating 10 years ago, or 20 years actually ago. Remember, the court is now 20 years, so the world has moved forward. We allow any sort that can allow your documents to be with us. So you can file electronically, you can PDF your documents and send them even by email. So long as they get to the registrar, it will be allowed. If you are closer to a sub-registry, you can walk there physically, deposit your papers. You can send by mail, registered mail, or anyhow. So long as we receive them, we shall accept them, and your matter will be given a number, it will have been filed with us.
And is there a charge to file a case?
Filing fees for cases in EACJ is free. And this came out of the need of the provisions of Article 7 of the treaty, that the community will be people-centered. So if it is people-centered, means you want people to make use of the court and enjoy the benefits coming from the court. Now if you put a filing fee, you are going to deter many people from reaching the court. So that was waived. And the interesting thing is that even after that was waived, there were fears initially that people will flood the court with all manner of cases. Any idle person sitting somewhere and he might just decide, let me go to EACJ because it is free. No. Incidentally, we get serious cases only coming to the court. And that should make access much easy to anybody. You know, anybody wanting to file a case when he goes to a lawyer, the biggest worry, first of all, is filing fees. Where will I get money to file a case? Now here we are saying you don't need that. So that has substantially reduced the cost of litigation in this court and has made access to justice much easier for the residents of the community.
And have any states filed cases against each other?
No, we have never seen that. Incidentally, they have a way of solving their own problems. So we are looking forward. Maybe one day they will come.
And on the issue of exhaustion of local remedies, is this a must before one files a case before the court?
Now again, in East African Court of Justice, unlike many other courts, you don't need to exhaust local remedies. And again, it goes back to people-centered. How will you enjoy the benefits arriving from the court if you must exhaust all those local remedies that sometimes can take you 10 years before you get here? So we removed that. Coming to this court is direct access. And of course, it is also in line with the limitation period provided in the treaty of 60 days. Now, if you have to come to court within 60 days of whatever event that has happened, if you are going to file cases following the exhaustion of local remedies, then you will never reach here. You will be locked out before you are even heard where you filed the case first. So that was removed. You don't need to exhaust local remedies before you access this court.
Does the court recognize the principle of continuing violations when computing time?
Incidentally, we have decisions that say the court cannot recognize that. Otherwise, also we'll have floodgate of cases. So a cause of action arises on the date of the event of that violation. From that date, then you count 60 days. After 60 days, you're locked out. Whether that violation is continuous or not, you bring it within those first 60 days.
In terms of computation of time, does the court also include weekends and holidays within that 60 days?
Apparently, they include weekends and holidays, but somebody can apply to waive or to extend time because of those weekends and holidays. What we are going to do next in our revision of the rules is to be specific that when you're computing time, we will not include weekends and holidays, and official holidays, non-holidays. Just the way it is done at national level, you find in some countries from 15th of December up to 15th of January. That one is not included when computing time. So in our next revision of the rules, we want to be specific on that.
In terms of legal assistance, does the court offer legal assistance to indigents?
Apparently, the court doesn't offer legal assistance to litigants. It is a matter we are pursuing with a partner state to have some fund where we can help those who have a good case, but maybe they cannot access to court because of that. So we rely sometimes on institutions like East African Law Society, if they have time and they think they can take up the case. Just discussions on goodwill basis. But otherwise, the court doesn't have that system.
And who has the right of audience before the court?
Any litigant has a right of audience. The lawyers have a right of audience. And we go further. And the lawyers, of course, you must be having a current practice certificate. If it's the first time you are appearing this court in that particular, we demand it sometimes. Prove that you have been issued with a practice certificate. Now we have gone further. That a litigant can even appoint an agent. I may be having a case, but maybe I'm not good at talking. My expression is bad, and appoint somebody who is not necessarily a lawyer to be my agent, and he can still represent the real litigant as if it is his own case. So we have gone at least wide and make it easy for anybody to come to court and have his case heard.
And do lawyers from outside the East African region have right of audience before the court?
We have never come across any request like that. I will imagine a litigant will say he has a right to choose anybody to represent him, and such arguments can be accommodated.
In terms of hearings, it's twofold. Does the court hold hearings in all cases, on the one side, and on the other side, does the court hear evidence from witnesses, or expert or character witnesses?
All those are done in the court, depending on how one wants to present in case. We have instances where the lawyers will say, we'll only put in papers, we'll put in affidavits, we'll put in all our written evidence, read and make a decision. We have some instances where lawyers will say, no, we must put my witness on the dock. What comes from him will be more important to make the court appreciate. And we allow all those. Of course, again, irrespective of where the witness is coming from. And I said earlier, because of technology, we have had witnesses testifying from Dubai, we have had witnesses testifying from South Africa. So it's really even the witness did not come here. As long as we're informed in advance, we can arrange to hear the voice of the witnesses from any part of the world.
Now, on the issue of advisory opinions, who can file an advisory opinion?
Anybody can actually file an advisory opinion, but the ones we have had, one came from the Secretary General and one came from a partner state. This one, like from the partner state, was because of disagreement, not agreeing on what does a certain provision of the treaty means. A second one was filed by the Secretary General, again on the advice of partner states, where they wanted the court to clarify certain provisions of the treaty, what do they really mean. But in general, anybody, any resident of the community, because he's affected by the treaty, if he feels country A or country B or all of them are violating a treaty on such a ground, and they are denying, they are not doing it, they can say, okay, let's hear what the court says. And an opinion once given, it becomes a judgment. The definition of a judgment in the treaty includes an opinion. So once it has been delivered, it just has to be complied in the same way a judgment is complied with.
On interim injunctions, does the court hold hearings for all applications for interim orders?
Yes, it does. Once in a while, ex parte orders have been issued, then later on, inter partes is heard and interim injunctions are given. Then the matter is given priority because it was a matter that came under urgency, then eventually it is determined. So the answer is yes, it does.
And are all interim applications fast-tracked in terms of hearings and being considered by the court?
Due to the nature of the court's working, they are not fast-tracked. For example, we have a session now. Today is Monday. Somebody might file a matter and a certificate on Friday, and incidentally, that was the last day of that session. It becomes very difficult to fast-track that application. And there were more so when you consider that some of our judges are also serving judges in their partner states. So when they left to come here, they had a program. We are going to Arusha for this period. We'll come back at this period. They have other work waiting for them. So it becomes very difficult to fast-track that. But we are working on deploying again IT, so that even if they are gone and something is urgent, we can connect them online and the application can be fast-tracked.
And in cases where interim orders have been issued by the court, what options are there for the applicant if the respondent does not comply with the orders?
Well, then he's at liberty to apply for contempt, or if which can come in many forms, to cite the respondent who has refused to comply with it. Just like any other judicial mechanism, he's at liberty to do that.
In terms of public documents at the court, can non-parties to a state request to peruse files?
Our documents are public documents. So anybody coming, whether you are a party to that case or not, and you want to read it, you will be given access. Yes.
And besides seizing the court as an applicant, how else can one become involved in a case of interest?
There are two ways of getting involved with a case of interest. One, you come in as an intervener. You are coming in as an intervener because you are saying the outcome of this case is likely to affect me in manner A or manner B. So you apply, you give your reasons, you'll be allowed then to join in the case. You can also apply to join in the case as a friend of the court. In this case, you'll be saying, look, I understand the matters before you very well. I want to give you information that is not biased. I don't want to support party A or party B, but I just want to lay bare before the court information that might help them to reach a just decision. So you will have joined the court without you necessarily being a party to that case.
And is there a time limit to apply to be amicus or an intervener?
There's no time limit. Once the matter has been filed, you can come in. Of course, you can also again come in towards the end, the tail end. you have to come in before the hearing at least, so that then whatever you want to present the court is given an opportunity to be heard.
On the issue of implementation, the court has made some groundbreaking and progressive decisions, but these are affected by law implementation. Please kindly explain who has the primary role in ensuring implementation of a court's decision.
Okay, first of all, the person with the primary role in ensuring the implementation is the respondent, or the person against whom that judgment or ruling has been given. And that is grounded on Article 38(3), which says it is a violation of the treaty not to implement a court decision. So what we do once the judgment has been given, we take the liberty also to remind the respondents that you have to comply with this, with the judgment, because it is a provision of the treaty, and it is a violation of the treaty not to implement the court decision. In fact, we had a case where an applicant came back saying, look, the respondent has refused to comply with your decision. And a judgment was given again against that very respondent. And of course, costs went up again. Thereafter, the applicant went, he never came back, but the report we got is that now it was complied with.
And as a court, have you taken any initiatives, whether through workshop or activities or sensitization missions, to improve implementation?
We have done that, and we continue doing that. We are also telling partner states the effect of not implementing court decisions. You will be cited at an international level as a country that is not obeying the rule of law, and quite a number have been complying with the court decision. They may delay for one reason or another one. For example, we had a case where the ruling specifically directed the respondent to go and amend their law to be in line with the treaty. When we followed it up, because how we follow up is that at every Council of Ministers meeting, we do a report showing these are the judgments that have been given requiring the respondents to do something. As you know, there are others that don't require a respondent to do something, like declaratory orders. So we list those ones down, and the partner states give us a report how far they have gone in implementing that. So like we had one decision where the partner state was saying, yes, we have not refused to implement, but this requires legislation, and our parliament has been dissolved because of elections. So we'll wait until when the elections are done, we have a new parliament, then a bill will be published to amend this. So they do take some time, but more often than not, the decisions are complied with.
And on the issue of damages or reparations, is there an application procedure for this, or is that automatic when the judgment is delivered?
Well, it's not automatic, because first of all, you must have prayed for it. If you didn't ask, then the court will not come out with its own volition and give you. But where we have had a request for that in the prayers and it is justified, the court has always given reparations. Initially, they thought they could not do it. But when they looked at the law properly, they realized that they were seized with the powers to do that. It is futile for me to say, yes, your rights have been violated, but it's all right, go home. So what will stop me from violating them again tomorrow and tomorrow and tomorrow and tomorrow? After all, there are no consequences to me. So to stop that, the court said, no, we don't just say that. You violate somebody's right, then there must be some consequences. And that comes in the form of reparations.
And after a case is, an application is concluded at appeal level, is there any other option available to the applicants should they not be satisfied with the ruling of the court, even if the decision is in their favor?
The only available option is an application for review, because we have reached the dead end now. So we can only ask the judges, can they reconsider it again? Maybe they do not consider this point. Can they have a second opinion again out of it? Yes, otherwise after that, then it becomes a closed case.
Thank you very much for your time. I think that's all we had for today.
Okay.
Yes.